Welcome to our presentation, Motions for Substituted Service. I sure didn't expect to learn this in law school. This presentation is a variation on a presentation that we completed for ACL, which is the Association of Canadian Clinical Legal Education, in the spring of 2022. Your presenters today are me, Karla McGrath. I'm the founding director of the Queen's Family Law Clinic, and I'm also the executive director of the Queen's Law Clinics. And my co-presenter is Jamie Burns, who is a former student caseworker at the Queen's Family Law Clinic, and she's currently an associate with Hicks Morely. Today, we're going to be covering both the substantive legal matter of service and its the subversion or the version of service that is substituted service. We're going to talk about what it is, when it's needed, and how one gets an order. This presentation is directed at the students of the Queen's Family Law Clinic, the coming students of the Queen's Family Law Clinic. And so Jamie will also be touching on the student experience of taking on such work. A little bit of background. The Queen's Family Law Clinic is co-located with 4 other of the Queen's clinics. The Family Law Clinic, or the QFLC, is made up of 2 lawyers, both of whom are part-time, making up 1 lawyer. We have students who come to us both in the credit program, come to us as volunteers, and we have students who work for us full-time through the summer.
So, hi everybody, I'm Jamie, as Karla mentioned. I first joined the Queen's Family Law Clinic in September of 2018 as a student caseworker. And then the following year, I was also a clinic mentor. At the time when I joined the clinic, I had no experience in family law or knowledge of family law. I'm pretty sure I hadn't taken family law yet either. I might have done it second semester. But I was very interested in the area, and I was excited to be able to get some practical experience in law generally. And so you'll often hear Karla mention basically the goal of the clinic is high quality casework with minimal intervention. And you may be wondering, okay, what does that mean? So I also did at the very beginning when I started. And as I learned over the course of my time with the clinic was that at the beginning, you're going to have a lot of questions. And what Karla and everyone else working at the clinic is trying to help you do is basically get you to a point where you can use the resources around you to answer those questions. And if you finally get to a point where you've exhausted all of those resources and you still don't have the answer to the question, well, then you can turn to someone like Karla and ask that question. And you'll find that as you go, you'll learn that there's actually a lot that by doing the work and being involved with the work, you learn to do it on your own and then have that, gut check, but also be able to use the manual, use videos like this to help you along your way.
So the Queen's Family Law Clinic takes an approach to family law that is called the limited scope retainer, or sometimes also referred to as unbundled services. And this is an approach to law that has gained in popularity and is advertised by some firms as being their specific approach to family law. And through a limited scope retainer, you determine what specifically you're going to do for the person in the matter, and you then make it clear, and you will have a written retainer agreement that says that you're not doing other things. The importance of this in the private sector is that it provides it can provide more affordable legal services for some people who have some capacity to handle their own matter as a self-representing litigant, but they don't have the funds or perhaps don't want to spend the funds to take on a full representation model. At the Family Law Clinic, what we're doing is we're turning that a little on its head. By using public funds and applying that same approach, we are able to serve more clients, take on more matters. Sometimes we get the response from people that, well, you're just doing their documents. And first of all, I can assure you that we're doing a lot more than just doing the documents of self-representing litigants while we help them navigate the process. We're going to give you an example here today of what's involved in just doing someone's documents.
So as Karla said, we're going to run through an example. This was a case that I worked on while I was a caseworker at the clinic. And basically, this case, I think I had over 60 hours on this case. And as well as there was another number of caseworkers. There was one caseworker before me and a number of caseworkers after me who worked on this file. So you have to think about all of their hours on this case. And this was an example of just doing someone's documents. So I'll introduce you to Judy and Sean. So Judy came to us. She was looking for health services for her son, Sean. She had, he was experiencing some issues, and when she took him to the physician basically said, I can't provide your son services because I don't have the sign off of his father. So at the time, Judy was married, and she had been estranged from Sean's father for over 5 years, I believe, at this time. And she didn't know where he was. The last she heard of him, he was on the other side of the world. So Sean's in need of these services. She can't get them. So our plan basically was, okay, first priority is to help Sean get these services that he needs as fast as possible. So the first step, before I go into my plan, what the first caseworker on this file did was try and get in touch with the opposing party. So in this case, the father of Sean and the husband of Judy. The last time Judy had spoken to him, he was in a small village across the world, and she had the address for this village, but this village had a community mailbox, no personal mailboxes. So the first caseworker on this file tried to send a letter to this community mailbox and just see if we could get a response, whether we could get in touch with him, somehow get his permission or show that we found him, anything that could expedite this process so that Sean could get his services as soon as possible. After the letter was sent, the clinic never received a response back, and this was about the time that I took over the file. So here, what's the next step? So our plan is to bring an application for Judy to have sole decision-making responsibility over Sean so that that father's signature is no longer required, and Judy has this court document that she can take to the physician and say, here, I have decision-making responsibility. I can say whether Sean can receive these services. You don't need that signature. Well, what's the obstacle? Well, we don't know where he is. We don't know where this gentleman is. We have to bring an application that has to be served, the documents on the father, the opposing party. Usually, I say usually, this means delivering those documents directly to the person. But here, to the father, he had left the country, and in fact, he had been deported from the country, and Judy hadn't spoken to him in over 5 years. She had very limited information on how to get in touch with him, and we had to try and reach him, but we don't know how. So we turn to service.
Okay, so speaking broadly now, not about Judy and Sean, with regard to service of documents. So service of documents is a concept. It's not, you'll see here on the slide, delivery is not always service and service is not always delivery. That is something that you'll hear often when we speak about service. Service is usually delivery of the documents to the person, as Jamie noted, but service is really whatever Family Law Rule 6 says that service is. So this is Family Law Rule under the Ontario Family Court, which governs the Ontario Family Courts. family law rule, and in this case, family law rule 6 is the governing legislation, or is the governing regulation. So under family law rule 6, there are two main types of service. They are special service and regular service. And these two are different. There are different types of delivery that are allowed under family law rule 6 to meet the requirements of special service or regular service. And special service is a higher level of service. Special service is required for an initiating process. So if you have an application or a motion to change, or a Form 8A application for divorce, then special service is required. Special service may be also required in other circumstances where service and making sure that it happened becomes much more important. An example would be if the documents include something that could cause the person to be imprisoned. So special service is more difficult, and it's when we cannot meet the and regular service has things like mailing at their address of record. So regular service is usually quite easy to achieve. Special service, when you cannot achieve special service, you cannot meet those requirements, that's when you need to have an alternative. The alternative the main alternative is substituted service, and that's what we're here to talk about today. So substituted service is covered under Family Law Rule 6, sub 15, and which provides that a court may, on motion, without notice, order that a document be served by substituted service. So you have to bring a motion and ask that the court order what will be that version of substituted service. And the person bringing the motion has to provide detailed evidence explaining what steps they have taken to try to locate the person, and also to show what their sub is, what their alternative means of service is, and that it would be reasonably expected to bring the documents to the attention of the person. So we're just following Rule 6, sub 15, to achieve substituted service for this person who we cannot locate to serve in person.
Okay, so why might you not be able to locate the other person? You know, this is often one of those questions that you think about and you go, well, why wouldn't you be able to, right? These days, you should always be able to get in touch with people some way or another. Well, the first reason that the clinic often sees people where you can't find, where it's difficult to locate the other party, is what we call party on the lam. So this is where the person is deliberately separated from the situation or family unit. So this could be that they've made that deliberate choice to just break apart. You know, it could be one of those things where people delete each other off social media, distance themselves, move away to be as far apart as they can. Or that person could be deliberately not wanting to be in touch. So not responding to calls, not responding to emails, just basically ignoring the person. So that's one reason. And then the other one is long separation. So these people are people that have fallen apart for a really long period of time. It could be years, could be decades. And at that point, they don't have anybody in common anymore. They don't know where they are. They don't know what they're doing. And therefore, you're not really sure how to get in touch with them. You don't really have any connections. And so Judy and Sean's case is quite interesting because it's kind of a combination of the two. So for a period of time, Judy and Sean regularly saw the opposing party in this matter. So the opposing party, he was deported from Canada. And for a while, Judy and Sean would go visit him in the village. And he was often, they still kept up their connection and their relationship. And then at a certain point, the opposing party threatened to kill Judy, and she broke off contact with him. But Sean kept in touch with him by phone and regularly communicated with him. And then further on, Sean was speaking with the opposing party. It came out that Judy was dating, and the opposing party then said to Judy, well, one of those men can be Sean's new husband, and he deliberately cut off contact with them and no longer communicated with either Sean or Judy. So here we have this deliberate break, so the party on the lam, but we also have long separation because, as I said earlier, it's probably been over 5 years. Well, now probably over 7. I don't know how long it was ago that I was at the clinic. A significant period of time since Judy has talked to, or Sean has talked to, the opposing party here.
So the most common reason that we do see both, and the most common reason why we find the clinic will be bringing a motion for substituted service is a long separation. Usually in our cases, it's usually done for a motion to change relating to an accumulation of child support arrears, sometimes again over decades. And then those child support arrears are being enforced by the Family Responsibility Office. We have a whole other video for that. We call those the Gideon files. And also for uncontested divorces. There are people who having separated, just fall away from one another, and neither has the resources, be it money or information, with which to pursue a divorce, even if they don't have corollary issues or no longer have corollary issues between them. And then somehow they come across come to us, and they want us. We have to start by getting them finding the person, and if not finding the person, bringing a motion for substituted service so that this person can get a divorce and, for example, marry their current partner. In this particular case, it was for an application for decision-making responsibility and parenting time. And the motion for substituted service process is the same, regardless of the matter. And so it's the same process that we would follow for motions to change and for uncontested divorces.
Okay, so when we look back at the family law rules, step 1 for a motion for substituted service is that you have to prove that you can't follow the requirements for family law rule 6. So basically that you can't affect special service. So you have to prove a negative.
So proving a negative. Students will come to me with not every student will get to work on a motion for substituted service. And so working in supervision meetings with the student who is doing a motion for substituted service, I'm explaining to them that the first thing you have to do is you have to prove to me, so that we can prove to the court that we cannot find this person such that they can be served. And to do that, they have to start by looking everywhere, and they look everywhere, including through our client. They have to ask our client lots of questions, and they have to pursue it themselves as well. And we have a number of online resources that Jamie will speak to some of the work that she did. So what I'm doing is I'm calling on the student to imagine every way they could in order to be able to find this person. And I'm calling on the student to require that of the client. Like, just imagine for a moment that we have absolutely no choice, because quite reasonably, we actually have no choice, except for the choice that comes to us, or the option that comes to us from examining every possibility. And so the student then becomes essentially a skip tracer. They're going to identify leads, they're going to follow those leads, they're going to find more leads, they're going to follow more leads, and they have to be creative, because they have to imagine what I'm going to come up with. Have you tried this? Have you tried that? I have to imagine what the court's going to come up with. And we together have to identify all those gaps, and then fill all those gaps and put that case before the court, so that there's nothing left for the court to say, yes, but have you done this? Or yes, have you tried that?
So the first step for this as a student caseworker is really about gathering that information from your client. So you're going to have not just one meeting, but probably a number of meetings over a period of time with your client, gathering this information. And you're going to ask different questions. A lot of them, a thing is that you're going to ask a question and you're going to have follow-up. So you're not always going to know what your question is going to be until you ask the question. So I would start by asking questions like, well, when did you last speak to the opposing party? Okay, and Judy's case, she hadn't spoken to him for years. Okay, but my question was, okay, so how did you speak to him? He's out of the country. So did you phone, email? How was this communicated? And so in her case, well, I talked to him over the phone. It was a number to his mother's house. Okay, do you still have that number? Can we call it? can you find it? And she's like, well, it's been over 5 years. I don't know where the number is. Okay, well, can you go look for it for me? And she's like, yep, can do that. And then you're going to talk to them about other things like, okay, well, do they have any siblings? Well, yes, it's 2 sisters. Okay. When did you last talk to them? When did you last see them? Where did you see them? All of these questions, you're trying to fill in all those gaps so that when you're going to do your own research to try and find them, you have the information that you need, and basically all of the things that could lead you down to different paths. For instance, in Judy's case, she said to me, well, I know his mother just died. I was like, okay, well, how do you know that? How do you know that his mother just died? Well, I saw it in a newsletter. It's like, well, what newsletter? Well, she followed this newsletter from this little village that he lived in, and it had her obituary. And so, well, do you still have it? Do you know what it was from? Things like that. And often, sometimes you'll get the answer, the standard answer, well, I don't know. Okay, well, I don't know is not, you can't end with I don't know. You have to unpack that more, because if you just ask them, well, where are they? Or have one, do you know where they are? And they say, I don't know. Okay, well, you got to unpack that further. Just like I did with, well, okay, if you don't know where he is, well, when was the last time you see him? Where was he? All of these questions. And then pack, okay, well, what kind of work does he do? Do you know where he worked before? Things like that. So you have to keep unpacking I don't know until you get down as far as you can. And then you're probably going to go do some research, and then you're going to come back and you're going to have other follow-up questions. Or you're going to talk to Karla, and then she's going to have questions that you didn't think of. So it's really this give and take with your client, and really having those conversations and making sure that they are being forthcoming with you and providing this information. And often it can be very difficult for them, which Karla is going to speak to.
So the client may not be motivated to find the opposing party. People split up for a reason, and there may have been domestic violence. This may just be a very difficult breakup that the person does not want to revisit. Excuse me. I suddenly have a frog in my throat. There may be other concerns that you're not aware of. And we have found that clients, and I found this when I did a lot of motions for substituted service work as a duty counsel as well. And I've often found that it appears that the client thinks that there's some other option. Like if they just keep saying no, if they just keep saying they don't know, then I'm going to come up with some other option. And so it becomes a client management issue, because I do have another option, but it requires that they answer these questions. And we're not going to be able to move it forward. And one of the tricks I used as a duty counsel, I say tricks, one of the methods I used as a duty counsel to really get inside the client's head and motivate them to get over to my side to answer all those questions and to move away from that I don't know, is to say, okay, I have a check, and that check is for, insert an amount. I say that check is for $100,000, and all we need to be able to, for you to be able to cash this check, is to get her signature on the back. Now, tell me where I'm going to find her. And then the person would say, well, she has a brother who lives in Hamilton, or words to that effect. It never failed. And I don't know why, but it just does something to flip the client over from thinking that there is another option to thinking about this from the motivated standpoint that we're looking at it. It's just like come up with every single possibility. So we'll start with that brother in Hamilton. We also have a class exercise that we'll do where we'll do a subservice gathering of information with a client, with me as the client and the person on whom we're going to we're looking to have substituted service, and or looking to find the person so that we don't have to do substituted service, is my high school boyfriend. So there's an opportunity there for students to go into that question asking mode with a group of other students, and then to hear all of the different possibilities that they'll come up with. And then I play the part of a resistant client and don't only answer the questions that are put to me really directly.
Okay, so now we're getting into research. And as you can see on the screen, there's a long list of methods that people have used in the past to try and locate the person being served. And I'm just going to talk about this more in terms of Judy and Sean, so I can give you an example of what I did when I was trying to find the opposing party. So social media is often one of those things where you might be able to find them, because a lot of people these days have some sort of social media site. But you run into difficulties with social media because you have to both prove that it is that person that you're looking for, as well as that that person is active on the site. And with your client, what you're going to need to do is, well, in Judy's case, there were no social media accounts that I could find for the opposing party with his name, just generally nothing. But for his sisters, I was trying to locate his sisters on social media, and there were a number of accounts that could have been them. But my questions for Judy were in relation to them. Okay, well, do they have nicknames? Do they have a different last name than the opposing party? Are they married? Those are all relevant questions in terms of finding someone on social media. Do you know their middle name? So I could look and see if I could find any iterations of their name or possible names on social media sites, as well as, do you know where they were last located? Okay, in these cases, well, you can look for the location, you can look for the hometown, things like that on social media sites. So these are all questions that you have to dive into with your client. And that's what I did with Judy. And so we had a number of pages that I had found that could potentially have been his sisters. She had previously had them on social media, but had stopped, had unfriended them. So a number of years ago. So I was trying to find these sites. And so to do that, I would take screenshots of the profile pictures or pictures of them. And then I'd go back to Judy, have a meeting with her, or send her an email with the pictures and say, well, are these his sisters? Any of these his sisters? Then she ended up saying, no, they weren't. I ended up couldn't find them on social media. And then other ways. So I knew that his mother had passed away. I found the newsletter that I was speaking about earlier, where it showed that his mother had passed away, and it mentioned a church in this little village that did the funeral. And so I was like, okay, well, maybe I can get in touch with this church. Maybe they have contact information. Maybe he was on for the funeral. And so I searched and searched, and I could not find this church. They'd had no web presence, nothing. So what I did was I looked for other churches in the same town. I ended up finding one, and I communicated with them via, I think it was Facebook, and I tried to ask them, okay, well, do you have contact information for this church that seemed non-existent but was somehow on an obituary? And they went, the people I was communicating with were very nice. They went and they asked the church, and they had no way to get in touch with them. They were like, there's no phone, there's no website. I was realizing how small of a village this was when I found this out. And then I also asked them if they knew the opposing party and whether they had contact information for him. And unfortunately, they didn't know either. So this was another dead end that I reached. And so one of the things that I tried, other things, I did a number of Google searches, tried different areas. There was a chance that he was in jail or prison, so tried to look for those. And then Karla's probably going to tell you about Canada 411, which is basically a phone directory lookup, which for Canada. And I was able to find the equivalent of that for international calling. And so what I did was I looked up and tried to find a number for him or a family member of his. And I ended up finding a number on this international directory for a place across the world and so I called this number, and didn't get an answer the first time I called. There was no answering machine, so I tried it again. And when I called this time, I got in touch with someone answered. It turned out to be his niece. I was able to talk to her and ask her, so does he live there? And she confirmed for me that he did. And I asked if I could speak to him. She said that he wasn't there at this time. I asked if I could, if he would be back, and there was another time that I could speak to him. And she said, no, he was going to be away for a while. She was not willing to give me too much information over the phone because she didn't know who I was. And then I asked if there was a way that I could mail documents to him or get documents to him if there was an address there. And she gave me the community village mailbox, said that that was the only way to mail to this village. And so I asked whether she or he could pick up documents if I was to mail them to this for him. And she confirmed yes. So this was my conversation with his niece. And this was my potential method of substituted service, which after I had reached so many dead ends, it was very nice to be able to say, I talked to someone. Karla remembers how happy I was. But let her go on here.
So again, what we've asked the student to do is to prove that they can't find the person and to look really hard so as to prove that we can't find the person. And in doing that, the student may look so hard that they in fact find the person. If they find the person such that they can serve them following Rule 6 and doing special service according to Rule 6, then no problem. There's a student reaction. I've more than once had a student react going, oh my God, I found him. Now what do I do? Well, now it's fine. You don't have to do the motion for substituted service. They've just become so razor focused on how to do a motion for substituted service well that they lose sight of the fact that the actual goal is to not have to do a motion for substituted service. But more often, what they'll find is some trace of the person or a trace of a person connected to the person. And so that information is excellent information. And because it gives us that second part, which is a choice of a choice of an alternative option for service. And so that information, and it may provide multiple options. And so that's going to guide how we're going to frame that part 2 for the court. What is this reasonable option that we are offering the court, having proven already that no other option, that no Rule 6 option is something that we're going to be able to achieve.
Okay, so when you're doing this research and you're communicating with your client, I cannot reiterate this enough, but documenting is crucial. So when you're basically save everything, document everything. So if you're taking screenshots, make sure you save them in the file. If you're making a phone call and no one answers, make sure you write that out in the notes. Okay, what date did I call? What time did I call? I got no answer. I made a number of other phone calls in Judy and Sean's file and I didn't get responses back, or I talked to someone who said, well, that person's not here. You have the wrong number. Documenting all of that information, because all of that is going to go into your motion for substituted service, and you're going to need those details and that level of specificity when you're completing the documents. Make sure that you write down all of the information that your client provides to you. So and what they do. So if they tell you they went and did something, you want to document that as well. So in Judy's case, she went and looked for the telephone number for the opposing party. She tried to locate him on Facebook herself. So making sure that I'm documenting those conversations that I'm having with Judy, that she did these things, because you're going to put that in your documents as well going forward. So making sure all of that is in your file and in detail, so that also with the clinic, because you have so many caseworkers, someone's going to be able to need to read your file afterwards probably. So make sure it's all there for the person after you, because you want to make sure for your client that they get the best care as possible.
We'll just touch briefly on the available case law for substituted service. There isn't a lot of it. We have a couple of cases listed here, and these cases are similar to what we're doing here. They're taking you through the rule and and restating the rule and applying it to some degree. One of the notes here: reasonable is a case-by-case determination. And so you have to look at your situation and determine what's reasonable in that particular situation. I would suggest that certain types of cases will, the threshold for substituted service can seem to change, can seem to be adjusted. The more dire or permanent or unfixable the result is, then perhaps there may be a higher level of expectation for substituted service. Similarly, if it's something that could be changed again in future, that the court may be a little more forgiving on the subject of say, for example, what is a reasonable method of service, because it's not that if the person isn't notified, if the person ends up not being notified, it is something that once they are notified that they can come back and for which they can make a change. That's more of an observation over time that fits in with reasonable as a case-by-case determination, which is noted in this case that we have listed here. This 2020 case reaffirmed that detailed evidence is required. It is detailed evidence, and including, because we are proving a negative, detailed evidence about the things that didn't work. The fact that you tried, and the fact that there was no that did not lead to the person, helps to make the conclusion that this is not an option. That finding the person and serving them is not an option. Where the request for relief cannot be taken lightly. That was in response, as I recall, to there was a request that this person was making that was like to say, I don't have any resources, I don't have the ability, I don't have the financial ability to effect service, and that was not a consideration. The fact of the matter was the person just had not provided the detailed evidence to show that they had tried to locate the person and had tried to effect service the way that Rule 6 requires and is stated to require. So coping with expectations, you've heard this a little bit already through Jamie, I think, and she's already had that reflection herself that, as a student, she was thinking, well, you got to be able to find the person, right? So there are these expectations generally, and the biggest concern, of course, would be that there might be that expectation with the court that, well, it's 2022. I mean, everybody's findable, and within some amount of reason, everybody is findable. I know I'm pretty findable on the internet. But there are a lot of people, and our clientele fall within a demographic of a lot of people who are not quite so easily found. And they won't have landlines, so they're not necessarily, they're more so likely to rely on cell phones, and not necessarily the same cell phone over an extended period of time the way some of us have. They may or may not have social media or easy access to social media. They may not have the devices. They may not have access to reliable Wi-Fi such that they learn to use social media and rely on it as much as many of us do. So what you want to avoid is, or not avoid, but what you want to overcome is this sense that, well, it's 2022, surely to goodness we can find this person. Not necessarily, and you may have that you as a student, you may have that expectation yourself, only to meet some of the obstacles that Jamie's describing here, making it realize that in different places and for different people, how findable they are on the internet is varies quite significantly. But again, when it comes to the court's expectations, to a judge's expectations, meeting those expectations by addressing all of the different possibilities and doing the searching and coming up dry is how you're going to prove it to the court. So step 2, we've now determined that we cannot find the person, at least not for the purposes of service, proper Rule 6 service. We may have found some trace of the person. So now what we're going to do is prove to the court that our chosen alternative to proper Rule 6 service is a reasonable option.
So here are some examples of options that have been used by the clinic for substituted service in the past. So the first one, social media. So for instance, as I was talking about earlier, for instance, if you were able to find someone on Facebook, you'd have to demonstrate that that was the person. So if they don't have a profile picture, if they don't have pictures, it's going to be very difficult for you to prove that that is the actual person that you're looking for. But say you have a picture and you can say, okay, that's the person. My client can identify them. Well, then you also have to show that they are actually active on Facebook. Okay, so they can't have not made a post in years. They've got to actually be using it such that these documents, if you're able to do substitute service via Facebook Messenger, that they would actually come to their attention. So say I can show that they, wrote, had a happy birthday, responded to happy birthday post just like 2 weeks ago. Okay, well then we might be cooking in terms of this. Another could be through a relative or an employer or parole officer, lawyer, and then family responsibility office. So the family responsibility office will often look at them and go, well, you're taking money from our client to give to the opposing party and you don't know where the opposing party is. Well, that's just not right. So yes, we're gonna serve you and you can say, there they are. So they're not very happy about that, but we're fine with it. And then also you've got email, mail, courier, those sorts of methods that you can't do special service, but you could maybe do substitute service. And that's what we have in Judy's case here. We have this village mailbox. I have demonstrated that someone will be able to pick it up who is in contact with the opposing party. So this is the method of substituted service that I was proposing to the court could reasonably bring these documents to the person's attention.
So methods of substituted service, the rule says using a method chosen by the court. So that implies that the court's going to choose a method. And this doesn't just apply to this sort of motion. You don't go to the court and ask them what they want to do. And that can be a big shift, certainly for self-representing litigants, but also sometimes for law students and young lawyers. We're not going to the court and asking them what they think. We're going to the court telling them what we want them to think. So they're going to choose an option here, but they're going to choose an option from our options. We're going to present them with the options and they're going to choose one. It would be a very unlikely case that the court would then would choose something other than the things that we have offered up in this case. We can offer multiple methods of substituted service. So, and those can be cumulative or they can be in the alternative. If they're cumulative, one would argue that it increases the chances that the person is going to be notified. So we're going to send it by regular mail to his mother at this address where she has lived for 25 years. We don't necessarily know for sure whether or not they have an ongoing relationship, but one would assume that a person, at least, that a mother at least knows where she's going to find one of her adult children. So we could send it to his mother by regular mail, and we're also going to send it to him via Facebook Messenger on his Facebook account, which we will have established in the affidavit is that we've confirmed that it is his Facebook account and that the Facebook account appears to be active in as much as there are postings there. So offering those options, and again, possibly offering them cumulatively will only increase the chances of us having it be considered reasonable per Family Law Rule 6 sub 15.
So turning to your documents. So now you're ready to start writing your motion for substituted service. So what are you going to need? So you're going to need your first, which is a motion. So Family Law Rules is Form 14B motion form. So this is going to state what the party wants. Okay, well, here, what we want is we want to serve these documents on the opposing party in this method. Then you're going to have your affidavit. So you could have multiple affidavits, but so this is Form 14A affidavit. And so you're likely going to have an affidavit of your own, so this caseworker, and then also an affidavit of your client. And this basically, these affidavits are going to go through exactly what you did to try and find the person, all those roadblocks that you met anytime you couldn't, and then how you did eventually find the person, not necessarily so that you can do special service, but that you found them or someone related to them enough that you can do the substituted service, and then why this would be a reasonable alternative. As I said, there could be multiple, I guess there could also be multiple caseworker affidavits too, if multiple caseworkers have worked on the file. And then finally, you're going to have a draft court order. So this is Form 25 order. And basically, this is exactly what you want the court to order. You make it really simple so that the judge just has to sign it, be done with it. Here is your order. Lovely, presented, all done. Okay, so tips for completing your affidavit. So I talked about documenting already. So we're going to take all this documenting that you did during the process and you're going to put these into your affidavit. And that's why you want all those details, because you're going to explain in detail exactly what you did, what date, what time, what you did, and then what the result was. As you write your affidavit, you might realize that there are gaps in your research. And you remember, you're proving this negative. So if there are gaps in your research and the judge can look to it and say, well, why didn't you do this? You need to realize that before you put it before the judge. So writing this affidavit actually might help you realize that there might be some alternatives that you didn't consider and that you need to before you submit these to the court. You want to make sure it's organized. So you definitely want headings, because they'll help you organize not only your thoughts, but also for the judge's own reading of it. Could be in chronological order. It could be organized other ways. For instance, like if you did a number of phone calls and social media searches, maybe you separate it out by category rather than chronological order. It just depends on what makes the most sense. But again, with this, those headings are crucial. And then finally, you just do not want to assume that the judge knows what you're talking about. So you want to put in enough information that they can explain what it is you did in a way that anyone who would read it, even if they didn't know what you were talking, even if they didn't have knowledge of it, would be able to understand it. So for instance, when I found this newsletter and this obituary in the newsletter, I would have to explain, okay, well, what does the newsletter cover? What area? I'm explaining basically where you can find it, all those sorts of things, and what date, and then providing that document as well so that the judge can see it and then put everything together in a logical, reasonable fashion. And that's how you're going to write it. Basically, you're going to write it so that anyone who reads it would understand it. And that are my tips for completing affidavits. And so here is an example of a Form 14B motion form. So this would be, yes, this is basically with a few words changed and addresses changed. This would have been what we would have submitted in Judy and Sean's case for the motion form, just as an example for you.
So you'll recall back to the start when I said that this was an alternative. So we have Rule 6, and then there have to be alternatives for when we can't meet Rule 6, and that substituted service is the main example of an alternative to Rule 6, to basic Rule 6 special service. So another alternative is that service not being required, or as we call it, dispense with service. So that's Family Law Rule 6, sub 16. Having proven that there is just no method of substituted service that could possibly reasonably be expected to bring the documents to the person's attention, it's a very high threshold, as demonstrated by the fact that I just said possibly. Like I said, there's just no possible option. That's really what you're going to have to prove in order to be able to establish that there should be dispensing with service. And in that case, you might still get turned down, because the concern there is, and I didn't really go into it earlier, but I mean, service is particularly special service when it attaches to an initiating process. This is your opportunity. This is the party's opportunity and the court system's opportunity to notify a person that their rights are being affected. Like, there are going to be decisions made about this person's some of their most fundamental rights. And so we have an obligation to do everything that we can to make sure that they're notified. And so that's what you're up against when you're asking that the court dispense with service. You're saying, I can't do it, and therefore I shouldn't have to. That's a very high bar to cross or to clear. So the other option is Family Law Rule 6 sub 18, which is approving irregular service, or often referred to as regularizing service, and not ever by me, just so you know. To approve a regular service is quite similar to substituted service. You're doing it after the fact, though. So you have already delivered the documents to the person, and you have some confirmation. You can provide the court with some confirmation that the person received the documents, even though you did it improperly. Like, you sent it by regular mail, when obviously face-to-face personal delivery is something is the gold standard, that would be an example of what's required. You sent it by regular mail, and you now have confirmation that the person received it. It could be a text message from them saying, hey, that doesn't count. You sent it to be by mail, and you're not allowed to do that. Didn't count until you said that, sir. Thank you very much. So the other option would be if you can prove that the person would have received the documents, but for the fact that they are evading service. So you either confirm that they got them, or you can provide some evidence that they're avoiding getting them. So you put them in the mail, and for example, you mail them to the person's house, and in their handwriting, they return the documents. So you can see it, return to sender, written in their handwriting, and they're sending them back. They're trying not to receive these documents. So you can prove that to the court. But again, this is after the fact, whereas with substituted service, you haven't served the documents yet, and you're asking for permission to do it a certain way. Here, you've done it successfully to your view, although just not squarely with Rule 6. And now you're asking to have the court go back and approve that. Couriers are good for that, by the way, because if you can get the person to sign for something, boom, you've got proof. You've got some confirmation that they received it, whether they send you that little text message or not. So some concluding thoughts. This is a excellent exercise for problem solving. That's really what it comes down to. Problem solving is what we do. We have a lot of perceptions, and there are a lot of thoughts around what it is that we do for a living. Most of them come off of TV and movies, and they show a lot of grand oration, and there's a lot that goes on in the TV and movie persona of lawyers and litigators, family law lawyers. That's not what we do. We do a lot of problem solving, and this is a really excellent example of that. And you're learning to solve those problems yourself. You're learning to operate with your own resources to do that. So in that regard, this is an excellent teaching tool. I have a real privilege of being present sometimes in actual moments where you're watching a student's brain just start to bend around thinking like a lawyer. And again, this is an excellent example of the kind of problem that a student will be working on when I get to observe that. Access to justice. Can you imagine, Judy and Sean, can you imagine what this situation presented for them? So, I mean, when they first came to us, the fact that there was a physician who was refusing this child service was an absolute, we were aghast. And we did actually try dealing with the physician first, because it's just not correct. It's just not right. But the physician had made this decision for his own self, and nothing that we were saying was compelling him to do otherwise. And so we really did have to bring the matter to court. But then she tries to do this as a self-representing litigant, unable to afford it, and unable to get legal aid. She tries to bring this forward on her own, and the first thing she finds out is, well, you need to serve him. Well, what does that mean? Like, she doesn't even know what that means. Well, it's under Rule 6. What's Rule 6 of what? Think of all of the obstacles, all the things that you've just learned in the last hour that a self-representing litigant wouldn't know. And so she would have had no access to the justice that she really needed for her child, which was the ability to parent him on her own, which is what she was doing anyway, and the ability to get him the services that she needed. So it's really gratifying for me as a professional to be able to participate in providing that access to justice, but even more so to be there to watch a student as they have that experience of providing that access to justice for somebody like Judy.
And I would say that it was also very rewarding for me. I guess we haven't told you the conclusion of Judy and Sean's case, so I guess I'll share that. So Judy, we did get the order for substituted service. Before I left as a student caseworker, I did serve the documents as per substituted service. We never heard back. Judy did get her sole decision-making responsibility granted. And then also a caseworker after me went on to use the same method of substituted service to then get Judy her divorce. So Judy has now gotten both the things that she needed, and Sean has been able to access the services that he needs as well, which is wonderful. And fun fact, the documents that I served years ago returned to the clinic this year as a return to sender. So it's a great example of delivery is not service and service is not delivery, because those documents were never picked up or reached, and they came back to us. So, but Judy still has her sole decision-making responsibility and divorce. So I'm very happy. But being able to help Judy and Sean through that was definitely a very amazing experience, and being able to help them through that. But also, people will always tell you, actually many people will tell you that the things that you learn in law school will not be the same as when you're out in practice, and it'll be a completely different experience. The clinic is the type of place that you learn those practical skills that you're going to use in practice. I'm not saying that you don't need law school as well, you do, but all of those skills that I was able to learn, including documenting, including being able to communicate with a client and having those meetings on my own, being able to just send emails, make phone calls, draft documents. Those are all things that I now use in my current practice. The skills that if I had walked in off my first day at work and been asked to do those things, I had never worked for the clinic, I probably would have been a little bit very lost. I would have been very lost. Let's be honest. I would have been very lost, and it would have been a lot harder just to jump in terms of all the things that you're going to need to do when you're actually in practice. So that was great. But I also found it helped in terms of creativity, problem solving. You're going to use those skills in terms of your regular practice. I use those daily, and being able to start with, at the clinic, you have a lot of difficult cases and often difficult clients, and being able to have that experience as a student gives you more skills, but also thicker skin, and being able to know how to navigate those situations going forward, because you'll often have those, and that's just one of those things that happens, but being able to have already done it makes it a lot easier. And so those are just a few things, but I would always recommend that, especially at Queens, where you have that opportunity to participate in a clinic, I would always recommend to take advantage of that opportunity, and really delve in and make the most of it. So those are my concluding thoughts.
So I referenced earlier that we have another video, and this is the current iteration of that video. We are contemplating doing an update to address some updates that have happened in the courts, in both the process and the law. But for now, this is the Gideon video. And motions for substituted service is a small chapter of this video. And so the idea of doing a full video on motions for substituted service and going into a proper amount of detail is something that was that's been on our radar for some time now. So these two are a matched pair, and if you're watching this video and this other one is replaced, then whoever sends you this video will be letting you know that there's a different matchup for the Gideon motion to change. Although now that I've said that out loud, I guess I really have to pull out that update now. So that's us on motions for substituted service, and there'll be, so for the students, there's going to be lots of opportunity to discuss this in class and respond to questions. And for right now, I'll just want to offer my very sincere thanks to Jamie Burns for coming back and pitching in and providing this resource that can now be available to students at the QFLC going forward. So thank you, Jamie.
And thank you for having me. It's been fun.